This is Democracy Now!, democracynow.org, the War and Peace Report. I'm Amy Goodman with Juan Gonzalez.
Well, human rights advocates have welcomed the Supreme Court's stay of execution for a Missouri man who is set to be the first prisoner put to death since Oklahoma's botched execution last month. Russell Bucko, age 46, was scheduled to die by injection at 12:01 a.m. Wednesday for killing a man during a crime spree in 1996. His attorneys asked the courts to grant Bucko a stay because he has a rare medical condition which causes weakened and malformed blood vessels, as well as tumors in his nose and throat. They argued he could have experienced great suffering during the execution process. On Tuesday night, just over an hour before Bucko was scheduled to die, Supreme Court Justice Samuel Alito issued an order halting the execution.
Then on Wednesday, the court followed up with another ruling that said a lower federal court needs to take another look at the case. That lower court will be the Eighth Circuit Court of Appeals, which had lifted an earlier stay by a smaller panel of the court, which was based on Bucko's claim that the state's execution protocol, as it would have been applied to him, presents a, quote, objectively intolerable risk of harm, and that it's sure or very likely to cause needless suffering. For more, we're joined by Cheryl Pilot, one of the lead attorneys for Russell Bucko. She's joining us from Kansas City Public Television. Cheryl, we last spoke to you in February, shortly after your client, Herbert Smalls, was executed by Missouri. Welcome back to Democracy Now!, a different situation. You have been going nonstop since the execution time was set and you got the original stay. Explain what's happened to Russell Bucko and on what grounds has the whole Supreme Court ruled on the stay?
The basis for our claims is really grounded in Mr. Bucko's specific medical condition and the dangers that would arise from executing someone with that condition by lethal injection. And of course, the risks are heightened by the use of a essentially secret compounded drug about which there are no assurances of quality, purity, or potency. We had really solid opinions from some experts who agreed to work with us as the execution date approached, and they said that any number of things could happen to Mr. Bucko, and in fact those horrible possibilities were very likely and included hemorrhaging, bleeding into his throat, coughing, choking, suffocating. He has these vascular tumors in his face and in his head and in his throat, and any swelling of them could cut off his airway, which is already partially obstructed because of the tumors. And then there was the problem of whether the lethal drug would circulate properly in his system, and if it did not, it would lead to a prolonged and excruciating execution. So we had some very solid medical evidence, which actually was not controverted by the state, and we placed it before the courts, and we're very grateful that we got the stay of execution.
Well, this now goes back to the Eighth Circuit Court. Could you talk about that court and its record or history in dealing with capital punishment cases?
Well, the Eighth Circuit is very interesting. We got a stay of execution initially from a panel of the court in a 2-1 decision. And that was vacated by what's called the court en banc, the entire court, by a 7-4 vote, which was, of course, disappointing. There are obviously divergent views on a number of things concerning the death penalty, one of them, frankly, being the standard that needs to be satisfied in order to prove an Eighth Amendment claim. And I imagine that that will be the focus of any of the proceedings when we return to the Eighth Circuit. There are a lot of standards and what I guess the lay public would perceive as buzzwords tossed around. Do you have to show a substantial risk of serious pain? Does it have to be severe pain or excruciating? Do the risks have to be intolerable? There's a lot of argument around that, and there's also an issue about whether you can essentially plead and prove an Eighth Amendment claim without offering an alternative feasible constitutional means of your client being executed. And we, of course, have asserted there's grave problems with that. In Mr. Bucklow's case, of course, there's not even enough information known about how these secret drugs would interact with his system in order to answer that question. But at a more fundamental level, we think it's unethical to compel an attorney, or would cause an attorney to violate their ethics, to propose a means for the demise of their own client.